Great, Senate GovOps back. We're with Attorney Ben Groski, and we're gonna go over H644 and new draft. I think you all should have a new draft in front of you. This is about records for people who have previously been in foster care. So Ben, could you take us through this draft 1.1? Yeah.
Yes, with pleasure. For the record, Ben Obrogoski from the Office of Legislative Counsel. As Chair Hardy just mentioned, this is draft 1.1 of a strike all amendment to H644. Essentially what this does is adds a lot of language to give context to the committee for what these laws already do, and then makes small but notable substantive changes. So if you look on page 3, the addition of subdivision 7, previously read that that department records created under the subchapter could be released to an individual who's the subject of the record sought by the request, who's 18 years of age or older, and was a minor in foster care. That last prong has been removed. There was testimony that it could have been unduly restrictive by excluding those who were subject to be placed in foster care, but were not ultimately placed. So this would help resolve that issue.
Nice.
And then on for section 2, again, adding a lot of language to provide context for how family court records can be disclosed. The presumption is that everything is confidential in family court. However, subdivision B1 on page 4 outlines various exceptions to that. And there was a small change to subdivision E from the last version, which changed family court judge to superior court judge, which is the more accurate term.
So that's not a substantive change, it's just a technical accuracy change.
And then on page 5 and on to page 6, the addition of disclosure to an individual to mirror the language from the last section, who is the subject of the record sought by the request, 18 years of age or older. So those are the changes from the as passed by House version and this version.
Okay, are there questions for Ben? So the bill became longer mostly because I had asked Ben to add context so that people would understand, because it was hard with it without knowing which section was for which. So the first section is related to DCF records, the second section is related to court records. And other than that, they're very similar.
Well, and I should say too, there's a distinction. So it's records that the court possesses.
Right.
And then the subdivision, I know that there was some discussion for the DCF records about the placement of this in subdivision subsection D. It's upon request department records created under this section. So that is essentially broader than subsection C, which is the redacted investigation file. So it could go beyond the investigation file to include anything created by the department during.
Case notes.
Yeah.
It includes case notes. Go ahead. Now what?
Thank you, Madam Chair. I'm just kind of going back and looking at my previous notes on this bill and then this version. And I guess I'm just trying to understand. So thank you. This looks great. And I feel like it adds a lot of clarity. I can't figure out based on the description where the conversation around the two. So it seemed like there was an issue with the judiciary versus DCF with section.
With section what?
So there was a whole debate back
In 4921.
Yeah, it was a whole debate that we had about, yeah. Actually, and so you've expanded it to include more of that, so we have the context.
Yes.
Yeah.
Okay, but it does, who did we end up siding with, I guess is my question. I
So
don't
there was,
understand.
I mean, if DCF is asked to testify again, and they will after this, but they were concerned with because they didn't want to provide all of the records. They were worried they were gonna have to redact a lot. They didn't want to provide the case notes. So they were suggesting to put it in a more restrictive place.
Yes.
Other testimony that we got said, look, if you put it in a restricted place, you're not gonna get all the records, or the person requesting them are not gonna get all the records, they're not gonna get the context, and often the case notes is what has the story.
Right.
So what
But then the judiciary also had something though, because weren't we gonna move around some sections? Is it, oh, it is.
No,
It's-
the judiciary just, it includes, there's an extra section and who has, that has the same,
Okay, so we did, okay, so we did take out that,
Individual. Yeah.
and then we did.
There's a small grammatical change that needs to be made.
we didn't take out anything in the judiciary.
Oh,
We
okay,
added something,
thank you, that's exactly my question.
yeah.
It added the same two prongs for the individual as a subject and 18 years old to the judiciary.
Yeah.
And they're comfortable with that?
Yeah.
Okay, thank you.
Senator Watson.
Thank you. So a question that came up in our previous testimony was about the applicability of HIPAA or FERPA. And I recognize that this may be a question you're prepared to answer or may not be.
Partially,
Okay,
because I'm still looking into this.
okay, because just to say the question, wondering if, well, you're right, like how much of these notes or records or files might need to be redacted for HIPAA or FERPA purposes, but if they are about somebody else, if they are about them, if it's a mix of
Right,
people involved, I realize it can get complicated, so.
sure. Well, I'll take the HIPAA issue first. So HIPAA prohibits the disclosure of quote protected health information. This is really outlined well by HIPAA privacy rule, which is quite extensive. I can send it to the committee if you'd like, but I'll send it to you, do with it what you will. And so the disclosure of protected health information by quote unquote covered entities, and typically these mean health plans, healthcare clearinghouses, and healthcare providers who conduct the standard healthcare transactions electronically, sending electronic records. But it also includes many exceptions, including in certain circumstances when a state adopts a law allowing disclosure. So I actually have a question. Not necessarily for you, but for the department does the department consider themselves a covered entity under HIPAA? And if so, what's the basis for that? I would presume that they probably don't. But my further speculation, so again, keyword speculation here, I don't really know. Is that there probably may be some redactions needed, or there would be redactions needed if, for instance, the full medical file was included in what they needed to disclose. I could see a situation where they may want to redact certain information from that, but the other situation is that this is typically for the dissemination of material to others. This is the dissemination back to the subject of or so there's also another factor there. So I'm just curious what the sort of legal basis is of the concern, and then that would help direct my research and testimony to really help the committee out. So that's a really long way of saying, I don't really know yet, but there are some potential issues that I could see.
Okay.
And then as far as FERPA, so educational agencies may share information, but they're not required to do so. So FERPA also says that once a student reaches the age of 18 or is attending post-secondary school, the parents' rights to inspect and review the child's education records transfers to the students themselves. So again, if the student is asking for their own records, they have a right to see it once they're 18. So I would actually, again, ask DCF and maybe the Agency of Education how they consider these records. Because again, if it's, say, the attendance records that an investigator acquired from the school that now need to be disclosed as a result of a request by the student, technically they're allowed to do that. So again, without knowing more about the basis for the objection, it's hard for me to really navigate the real issue. Because again, when you're 18, you can access your own records under FERPA. So
Yeah.
Yeah.
So
that's the confusion that I have is
are
what's.
you able to stick around for a little bit?
Yes.
When we hear from DCF? Okay, Senator Clarkson.
So I think that children should not ever have a record redacted that concerns the health of their parents, because that is their health. There needs to be, I don't think I think every adopted child or a foster child, if it's a biological parent, they should be allowed to see whatever health record exists on their parents. We didn't hear complaints about education because I think FERPA seems to apply and people can get that information from schools and they should be able to get their records. But I think it's a little thorny here because I don't think that records should be that redacted. Kids need to know, or, the people we're talking about here need to know the full, both medical history of what of their genealogical tree, and they need to know whatever court actions, whatever the issues were that landed them where they are today or landed them into the system that they were subject to.
Mhm.
So I actually think there should be nothing redacted for children or foster children. I think they need to know the whole story, and I think that's part of what they're hungry for.
Yeah. Senator White.
Thank you, Senator Clarkson, for raising that point. I wanna know though, I can't just get my mother's medical records.
You
As a-
can if you're her Darby or.
Yeah, so do you get what I'm saying? Like, I can't just go and say, I would like to, right now, my, my mother, who is my biological mother and not in an adoptee situation, I can't get that information now unless I'm her guardian.
I don't think this is what this is doing. This is not providing the medical records for the
No.
parents. I mean,
Oh,
this is like a mention of a potential parents like substance use issue or
Yeah,
something.
okay.
This is not like their full medical records. This is like conversation about their,
Right, but they.
But
Okay.
I agree with the philosophical point that you were making, but
Yeah.
just so I understand, that's not what the bill is doing,
Yeah.
like, it doesn't open us up to adoptees, just getting all the medical records.
They already
Not
have.
directly from the
Okay,
provider,
that's what
but,
I was trying to.
but I think something that the community should be aware of is that it's possible during DCS investigation, they acquired those records and that's part of the file. And so that might be a basis for the redaction recommendation or concern that's raised by the department. However, there would be a difference between, say, the actual record of the mother that's provided by the medical provider, and then maybe the notes of the caseworker expounding on that. That's a record that's created by the department that would be disclosed, that wouldn't be subject to HIPAA because DCF is not a covered entity unless they consider themselves that, which.
You'll find.
Yeah.
all right, Senator Pivoski, then we're gonna do testimony.
Yeah, absolutely. I mean, I think it's a good point to make what this bill actually does. And, Senator White, to your point, you can't get medical records, but you could ask your mother. Hey, did this thing happen in a way that an adopted or foster child probably cannot?
That's
Right,
very
that's
good.
point.
Will she tell me the answer? No.
Well, okay.
Oh, there's another chance.
All right. We're gonna, spend, if you don't stick around, that's great, and then, now I've already forgotten your name, I'm sorry.
Brenda Gooley.
Brenda Gooley, if you wanna come up and, testify, that would be great. Hi, welcome. We will introduce ourselves quickly, because I don't think you've testified in here before. Okay, I'm Senator Ruth Hardy, I represent the Addison District.
Olivia from Garland Days. Senator Tanya Bielowski, I represent the Chittenden Central District.
Hi, I'm Senator Rebecca White and I represent the Windsor County District.
And this was Senator Norris, who just stepped out. He has a health issue, so he has to leave early most days.
Senator Ann Watson, Washington District.
Allison Clarkson, Windsor County District. And what's your name again?
Good afternoon, I'm Brenda Gooley, I'm the Director of Operations for the Family Services Division of DCF.
Okay. Well, you heard our discussion just now. We'd love to hear your thoughts on that conversation. And then I know that department has concerns about the bill. But
Yes, thank you. I wanted to say first and foremost that DCF is in support of ensuring that children or youth formerly in foster care have access to their records. It would be extremely helpful if the committee would define as specifically and clearly as possible what the record is. Because DCF is in a challenging position with the way the bill is currently written in terms of the amount of information sharing. If we share too much information, there could be concern that we are harming individuals whose privacy is being violated because of HIPAA, because it's criminal record, because it's information that is protected by a variety of state or federal laws that we could be sued for. So we need to be careful and thoughtful about that and would appreciate clarity from the committee about what is the intention in terms of what we should be sharing, as much as what we should not be sharing. Because really it cuts both ways, that we want to be able to ensure for the individual who is the subject of the record that they receive the information that they need to receive. But we also need to be careful about other individuals who are not the subject, but whose information is in the DCF record. And when I say that, I want to illustrate, for example, a household of 8 individuals. And a family services worker needs to go into that household, conduct a home visit, and they are obligated to make reasonable efforts towards reunification and document those efforts. And those efforts include their assessment of the needs of the child and the capacity of each parent to be able to meet those needs. So their case notes and other information in the file need to include detailed information about all of those individuals and how it may be impacting the subject of the record. So there's information in a file and in case notes that has a lot of detail about individuals' mental health histories, individuals' criminal histories, substance use. And yes, DCF is bound to follow HIPAA. Case notes, one of their purposes are to support that family services worker to do their job, to stay organized and clear about what they are doing in the household, what their assessment is, what the action steps they need to follow up on that. A secondary purpose of case notes is to document Medicaid case management targeted intervention. So there are aspects of that work that are audited at the federal level. We receive Title 40 of the Social Security Act funding for the work that we do. That information needs to be documented in those case notes for auditing purposes. It's a significant purpose for the case note. So we have to ensure we're documenting certain information that would be beyond information that is about the subject of the record.
so wait, just to be clear, you mentioned that you have to follow HIPAA. Do you consider yourself, as DCF, do you consider yourself a covered entity under HIPAA?
So we do comply with all of the HIPAA requirements.
That's not my question. Do you consider yourself a covered entity under HIPAA? Meaning that you are one of the healthcare entities that is not allowed to disclose information.
We do receive certain funding and we're the custodian of children in care. So I don't want to answer your question definitively without checking. So maybe I can provide follow-up on that.
Who would answer that question?
Yeah,
Your general counsel.
yeah, we need your general counsel to give us that answer because there's a difference between following HIPAA
Yeah.
and being a covered entity that can't disclose medical information.
Right.
And so of course you comply with HIPAA, but there are different levels of compliance depending on what kind of entity you are. So if you could have your general counsel reach out to Ben. Is that okay, Ben?
Yeah,
And
I know.
have that conversation with lawyer to lawyer about that, that would be helpful.
Okay, yes.
Okay, carry on.
So, you know, I think I will say too, there's a couple additional pieces in the most recent draft that are some inconsistencies in terms of information sharing that I think we would need to be able to take a look at. And so it's hard to have just a few hours time to really absorb that and respond to that, but I will say some pieces that did jump out at me right away, just looking at if, for example, if an individual has access to an intake that was screened out, there could be circumstances where,
I don't know what that means.
I don't think the current draft is any different than the first draft than as it relates to DCF, except for removing the line that says as a minor in foster care. Otherwise, it's identical. So
What's an intake is,
I,
I don't know.
just a second. So
you'd rather not go there.
no, I'm saying that you've had plenty of time to look at the draft because it's no different than it was
Okay.
before. But go ahead, Senator White. What was your question?
That's a very good point. It is a minor change. What did you just say? It's it would have implications for an intake with drop screening? What is it?
What does that mean?
Yeah, what is it?
I don't
I'm
know
not
if that
familiar with that terminology. Is that an intake of a child and then their screen? I don't.
Specific to when there are allegations of child abuse or neglect, if there is a request for anyone to be able to see any intake, and maybe that's not new information, so I mean, maybe
An intake is a complaint?
specifically it's an allegation of child abuse or neglect.
Okay,
Oh, it is, because intake makes you feel like they're taking in.
so you're saying that if someone could get access to saying that there was an allegation of child abuse, that you have concerns about that?
I think perhaps I misread that there was an expansion of the bill to include information sharing of allegations of child abuse or neglect that were not accepted. And maybe I misread that, and
If the
that's,
bill is the same as it came to us in respect to DCF, except for removing the line about having to have been in foster care. And the only reason that was removed was because there could have been somebody who you have a file on, but never actually was placed in foster care.
I do understand that piece, and that makes
Okay.
sense to me, that could be, for example, a youth who is in the conditional custody of
Correct,
a
right.
kinship or parent,
Yeah,
and that addition does make sense.
But it wouldn't just be the allegations piece. Is that kind of where the rub is? Am I not following?
go ahead, Ben.
Well, I was gonna elaborate a little bit on what sort of the intake and assessment
Yeah.
investigation process is, but this doesn't really touch on that.
Okay.
This would just say the person who's the subject of the records and is 18 years of age or older would be entitled to receive them. What was removed was exactly that foster language so that it wouldn't unduly restrict those that weren't placed. But still had records due to, through DCF.
So if there were records that included records of abuse and neglect, then the child would be, or the adult would be able to get those records because that's part of the record. So yes, it would,
So
that was the
okay.
same as it was before.
Great.
Oh,
Then I'll set that aside and say my final point is just from an operational perspective, wanting to comply with the law and recognizing that if DCF is needing to engage in a level of review of files and reviewing what is the information that needs to be redacted or removed, it takes time. It also depends on how broad the scope is of individuals coming forward to receive records. So I believe the bill says that it's enacted upon passed and would respectfully request time to be able to implement properly, which from an operational standpoint, depending on how many people were coming forward, would be a significant piece of work for the department.
So what what I'm hearing from you are the two requests are maybe some more clarity on exactly what records we're talking about.
Exactly.
And then time, so how much time? So that was changed, that we made it was July 1st, 2024, and we made it on passage because we got that request from another witness, but so how much time would the department need?
I think if we had a period of several months where we could really understand the scope of impact in terms of the volume of records requests, and then if we know what the record is, then we can train our administrative staff on these are the documents you need to prepare, these are the redactions you need to provide in order to then be able to share those records timely. So if we had several months to be able to do that, so perhaps
Is
September
July
1,
1st or
September 1.
September 1 is your request, okay? Senator Bielski.
A couple of things. My understanding of HIPAA is that it is, in instances of child abuse or neglect, the health provider is exempted from the HIPAA guidelines and allowed to share that information or make a report. And so I'm curious, and maybe this is a question for council, like how that interplay is, if the information was shared under an exemption to HIPAA, how HIPAA now covers it when it is no longer with that, being held by that healthcare provider.
Yes, so healthcare providers are mandated reporters. They are required to share information about if they feel a child is in harm's way. That could include failing to provide a certain amount of medical treatment. It could include the child's diagnosis if their needs are not being met. I would distinguish that from a DCF file where there's an individual in a household who has a major medical condition that's impacting the functioning of the child in DCF custody in that household. And so that worker is aware, maybe it's the sibling of the foster parent, or maybe it's a child of the foster parents, right? So that child might have a particular medical condition that's impacting the foster child. And the worker might be responding to how to meet the needs of the foster child and documenting what's going on for all of the children in the household. But then the individual who's the subject of the record is not necessarily privy to the medical conditions of their foster sibling. Right, that'd be an example.
Yeah, okay, and then as I'm reading, I had to go digging, I used to train on HIPAA and had to go digging through some of my stuff, but the American Academy of Child and Adolescent Psychiatry does state that many entities are not covered by HIPAA, including state agencies such as Child Protective Services. So I'm still like really trying to struggle with how HIPAA even applies. It's left the healthcare provider. The American Academy of Psychiatry doesn't set, quite explicitly says child protection is not covered by HIPAA, so I'm just really trying to grasp how HIPAA applies here.
Right, I mean, I think bottom line is if the record, if it were clearly defined what the record is, then there wouldn't be a situation in the future where someone would come forward and say, you shared my
Okay.
private medical information or my substance use history with this individual who had no right to know that, and you caused me that harm. That's what we're really trying to prevent.
Okay, so really the clarity is to allow you to share the information and protect you from future people who don't understand the really complex HIPAA policy from coming and saying you violated this law that you're actually not even subject to.
Correct.
Okay, thank you.
Senator Watson.
Thank you. So a couple of times you mentioned we could be more clear about the record and not being super familiar with the kinds of records. I mean, we've talked case notes and some other things, but I'm wondering what are the choices on that list? Like when you say be clear about the kinds of records, like what kind of records? I don't have the universe of what kinds of
Yes.
records you generate in my head.
Yes, so a DCF file has 6 sections. It gets divided into all of the letters and correspondence, case plans, disposition case plans, case notes, educational records, medical records, placement history, information that is in our databases that includes summary information. So if we were sharing the foster care file of the subject, it would be helpful to have a list that would say, you know, these are the documents that should be shared with this individual. That maybe includes things like the case plan, the disposition report.
Could you provide us with a list of the types of, the elements of a case file? And what those elements include? That would be
Yes.
really helpful.
Yeah, I could do that, and we could also include recommendations of documents to share.
That in writing, this would be helpful, and I'm wondering, even examples, if you have any that you
Yes.
could share with us. As to Senator Watson's point, if we want to define in the bill, we need to sort of know what we're defining. I think the intent of the committee, if I think the intent, if I might be so bold, is that we want the individual to have the information they need to know their story.
Yes.
And it's too much is redacted because you're being overly cautious about federal laws or the potential of future action. They're not gonna know, and the whole thing is pointless. So we want them to get enough information to know their story and to move forward with their lives based on what their true story is, without obviously causing harm to other people or causing you to violate federal law. But we don't wanna be so cautious that we're assuming somebody's gonna be like, oh, you violated HIPAA, when HIPAA doesn't actually even apply. So if those two things you could do for us, get us the information on what a case file is included and the information and examples of it. And your recommendations, we may or may not go with your recommendations, but it would be helpful to know what you think. And then if you could have your counsel talk to Ben, that would also be helpful. Senator Clarkson.
So thank you for summarizing my feelings.
Okay, good. I'm glad I-
And which Fred was already. I don't think parents here, you know, protecting parents have already created trauma for this child. I don't think the parents deserve me. I mean, I think they deserve some protection, but I think the child needs to know the story. Because until that child is, the truth will set you free. And I think that children, when they're adults, and we're talking about adults, they're not gonna be re-traumatized, they're asking for this, so they know that they may be going into tough thorny spot.
Yes.
So I don't think parents who have already traumatized children deserve to have their records protected from children who need to know the whole story.
But parents are not the only individuals that.
I don't care, I was all over who affected and traumatized that child's life.
Well, it could be
It could be
siblings.
foster parents,
Yeah.
it could be,
Fine.
it could be
I
the
mean-
children of the foster parents.
And
Well, I think getting us this information, we're gonna not be able to make a final decision on this bill today. And we do have another bill, we have a couple things, so Senator White, I'm gonna be the last word.
Yes, okay, so my only question is, and I don't know if you can answer this question, but what we heard was that there are records that the child can get before they're 18.
Yes.
That they could just request, and there's a lot of lawyers that they'll just say, give me the file so I can make sure that this person happens, so when they turn 18, they still have the right to access that information.
Yes, current
What-
DCF policy is that any child or youth upon exiting DCF custody, the worker is currently required to ensure they have their birth certificate, their social security card, their educational history, their medical history.
No, I mean the attorney. What we heard was that the attorneys can request all of those.
That's the court
things.
records.
That's the court records piece,
Yeah.
but what can they request that you give them now? Before they turn, like, is it the same? Cause they could get this information that we're putting in the bill. If their lawyer asked for it before it went away out of court. So what's the list of documents that
Not
you can give?
necessarily, Ben, do you wanna answer that question?
Well, I mean, the court administrator is right here too, so I might,
Or Terry?
yeah.
Well, in all honesty, I think the attorneys had said that they could request of DCF,
Yes,
all the records, not the court records, it's just.
yes, so what can the attorney request of DCF now, is the list of things I'd love to know, cause I'd love to have parity. Between what the child,
Well, it's not, so the court might be requesting records that they need or the attorney might be requesting records that they need for the case.
yeah,
And then in some cases, they would provide them to a child, but not like a 6-year-old child. They're not gonna give a court record to a
Yeah,
6-year-old
no, wait,
child.
I agree, I know, but I would like it that if they could have requested it as a 6-year-old, they should be able to request it as a 25-year-old. Does
Okay,
that make sense?
it might make sense. I'm not sure, cause there are some things that they might need for the court case that are different that, yeah, I don't.
Well,
But
Yeah, on that point, I mean, so one of the things that the department is permitted to do under the law is disclose these records to the court. Court proceedings in family court are confidential. So those aren't things that would be open to the public anyway and go through their own request process, which is partially covered by section 2 of this bill.
Okay, but the attorney can request any DCF document then?
I mean, they could request it,
Yeah,
they may not get it.
okay, I see what you're saying. Okay, that's, okay, yeah, I understand now, and,
Because right now there are a few things, like if you, and, you know, the beginning part of the context here that was included is helpful as well, because there are certain parties that can receive the redacted investigation file, and then there are certain parties that can receive records created by the department. And for this bill, the individual is under that category. Not the redacted investigation file, but records created by the department itself.
okay,
okay, so,
thank you, it's like my.
okay, if you could get us this is it possible to get us this information by Thursday?
We will try our very best.
Okay,
All of
Um,
the information requested. by
we're just
Thursday.
trying to, we have so many bills to get through and we're just trying to check this one off our list. It's definitely one we all want to pass.
Yeah.
We all,
So having the information as soon as possible will be helpful and having Ben connect with your.
I'll reach out to
Okay, perfect.
everyone like that.
That would be great, and we'll maybe, if we can get it by Thursday, then we could maybe get back to this bill on Friday. And if we need to make any adjustments to it, so thank you very much, I really appreciate your help. Thanks, Ben.
Of course.
We're gonna move on committee to another bill that we're still trying to grapple with a little bit. I have to leave it 4:30. I have to leave it 4:30-ish. So, we are gonna go to, H606. This is the professional licensure and immigration status. And, we have some, people, joining us on Zoom and then Terry in the room with us. Just to remind the committee of where we left off with this bill, this is the bill that would allow people regardless of their immigration status to be able to get professional licensure by requesting a number that's not a social security number, an EIN or
an identification.
some other identification. Yes, and the reason we're taking additional testimony today is that we discovered that the bill just covers professions that are licensed by OPR. And so there are professions that are not licensed by OPR that we thought, hey, maybe we should include those, but we wanted to hear from those representatives of those professions first. So that's where we're at, and I do want to remind everybody on the committee and the witnesses who might be waiting. The bill does not mean that people have lower standards or don't have to meet all the professional requirements to be whatever it is, to be a tattooist or a lawyer or a nurse. It's that they are able to get a different type of identification number. And also if compacts require a social security number and they don't have one because they're using a different number, then they can't get a compact. So just to remind everybody that where that,
Have a new draft or?
we don't have a new draft because we were waiting to see if we wanted to add different professions
Yes,
to it
that
or
was-
not.
yeah.
So wanted to hear from them first. So I'm looking for my draft, which I can't find. But
I have an extra one with writing on it.
Since you'll know Oliver.
we are gonna first go to, is Josh on? Yes, Josh.
Yes.
Thank you. We are gonna introduce ourselves to you and everyone else, because you're not usually in our committee. And then we're gonna hear from folks, And so I'm Senator Ruth Hardy. I represent the Addison District.
I'm Olivia Parker, I'm the committee assistant.
I am Senator Fanny Vyhovsky. I represent the Chittenden Central District.
Hi, I'm Senator Rebecca White, and I'm one of the Windsor County District Senators.
Senator Bob Morris would be right here, he is today. I'm Senator Ann Watson from the Washington District.
Allison Clarkson, Windsor County District.
So just thank you. So that is us. If you want to introduce yourself and tell us you are from the AOE, so teacher licensure.
This is David.
Correct.
First, Josh.
Josh.
Correct. Yeah. So good afternoon, everybody. Thank you for the introductions. Nice to meet all of you. My name is Josh Soulier. I'm the director of the Education Quality Division at the Vermont Agency of Education. We oversee one of the areas we oversee your teacher licensing. So thanks for having me here today to discuss H606. Would you like me to begin with some testimony?
Yeah, go ahead. Tell us what you want us to know.
Yeah, so I'll start by stating, I've reached out to my staff and we've reviewed H606, and it would not have any direct impact on our licensing process. If anything, it could help formalize our current practices. Currently, we will accept alternatives to Social Security numbers and issue licenses regardless of immigration status. In our experience, quite often individuals will start the licensure process well in advance of moving to Vermont. So while Social Security-backed criminal records checks are typically faster to process, a check without a Social Security number is still available and will process and can be just as effective. Education licensure and preparation outside the United States is far from uniform. As I'm sure you all know, governance of teacher credentials comes in many various forms across the globe. In some countries, non-governmental accreditation organizations qualify individuals with bachelor's degrees. And in other countries, it's more federalized work-study programs that issue these non-essential credentials. So evaluating each applicant's nuanced context is incredibly important. And our current process for licensure allows for this nuance. Applications pursue licensure through the Vermont AOE's transcript review process. If for any reason the credential is not equivalent, then we are unable to issue a license based on transcripts alone. They're directed to our alternative route, which is our peer review process, where applicants can use a combination of academic experience and work experience as long as they have the equivalent to a bachelor's degree. And this process, again, is the same for all educators, regardless of their status. So in our opinion, the H606 will not interfere with the agency's teacher licensing process.
Awesome. So
Yeah.
as it's drafted right now, it's silent to teacher licensing. We didn't realize that you already basically do this. Do you? Is it okay if we include you in the bill to like be proactive about it in the bill, or is that not necessary from the department's perspective?
I'm not prepared to answer that now, but I can definitely check in.
Okay.
But Emily's
For sure. Yeah.
Emily's not testifying today. She was going to,
Correct.
since you're legal counsel, but maybe if you want to check in with her and see, maybe it's just codifying your current procedure, and I think that would be helpful if possible, so that we all are, all the professions that can be are on the same page.
well, and shine a light on it, quite frankly.
Absolutely.
Helpful too.
Yeah.
Thank
Yeah.
you.
Yeah, so if you wouldn't mind checking in with Emily or having her reach out to me, that would be great. And I think there's a question, Senator Clarkson.
So Josh, I would love to, I know you have an extreme workforce shortage. So this license flexibility makes some sense given your workforce shortage. Can you give us would you be able to illustrate next time we meet you, how many current employees in our schools that work under a flexible licensure arrangement? That would be helpful to know how you
Yeah.
actually.
Yeah, let me check with the folks on our data team, and I'm confident that's some data that we could get for you for sure.
That would be great, because
So how, you mean, how many people are already using this
Yes.
non-social security? app?
and how long is it good for? So I know I've had temporary, sort of ability to work and teach in public school without the sort of standard licensure stuff used to require. But I know there's an end to that people have to comply and get stuff at a certain point. So is this open-ended, or does this have a timeline that's attached to it in terms of their complying with licensure?
Yeah, I can check with the folks with the subject matter expertise in our division and find that out for you.
Yeah, okay.
Yeah, that's
Yeah.
great, thank you. Senator DeHoski?
My understanding, and maybe this is what Senator Clarkson was talking about, is there is a sort of non-traditional pathway towards teacher licensure in Vermont. Is that true?
Alternative pathway, peer review.
Maybe that is what it is. I knew that there was a pathway. I remember one of my favorite
Yes.
colleagues in one of the schools I worked in didn't get a degree in education. In fact, was a musician for a long time and then became an educator and went through some alternative pathway. So I was just, now, can someone go through that pathway and
Yes,
use
they-
one of the alternative identification numbers?
Yes, they can. Absolutely. Absolutely. So they'll go through our transcript review process first. And if they don't qualify that, we encourage them and we'll support them in going through the alternative route, which is the peer review process, where they can use a combination of their academic experience and work experience, as long as they have the equivalence to the standards. Yeah.
Thank you.
Excellent.
Yeah. You're welcome.
Thank you. Just to be more specific about that, does the peer review process require any number at all?
We require we have alternative numbers that we can accept. Those can be anywhere from a federal employer number, an equivalent to a social security number from the incoming country. If not, we actually generate and have in the past placeholder numbers, so we can continue to transition this person and complete the process of the application and update the number, once we have that number.
Wow, it sounds like you're the model for what we're trying to do here. So maybe we'll send OPR to you all to have them all out with you.
And it's not their reputation, so your reputation isn't this, which is interesting. But maybe the workforce needs have required you to be more flexible than you have been in the past.
Well, I think this has been around for a bit, so that's nothing too new to our agency, our process.
Yay for education. All right, public education especially. Thank you, Josh.
It's public
Very
education.
welcome.
Really appreciate your testimony and the fact that you're already doing this and are a model for this. And if you have more information about whether we should write you in to just codify what you already do, that would be helpful, and then the questions. But thank you so much for being here with us today. Really appreciate
Thank you
it.
for having me.
Take care.
Thank you.
Next, Terry and Patricia, did you want to testify? Yeah, are you?
Sure, if that's okay.
Yeah.
Patricia Turley was going to be here in person, but she had, I guess, she was afraid to be a little contagious, so she's.
Oh,
especially
We're glad you are where you are then.
Awesome. Well, thank you, Patricia, for joining us via Zoom, and Terry for joining us in person. Do you want to kick it off? And then,
Sure.
then we can turn to Patricia.
Great, thanks. Terry Corson, State Court Administrator, and Patricia Turley is the chair of the Board of Bar Examiners. So she has much greater in-depth knowledge about the licensure process than I do, but I thought I'd give a brief overview in
Okay.
terms of what the rules are presently.
Yeah.
And then Patty graciously agreed to answer other questions too that may arise that occur to you. I'm going to apologize from the beginning because I didn't really focus on the social security number aspect of the bill. So I quickly had emailed both Patty and Andrew Strauss, who's licensing counsel, saying, do we even require social security numbers? I don't know, but I can address the rest of it, and Patty.
I did too.
Afterwards. So in terms of attorney licensure in Vermont, the Vermont Constitution vests authority with the Vermont Supreme Court in terms of the administration of the courts and disciplinary authority over judges and attorneys, which led to basically their authority to promulgate rules of licensure for attorneys. So there are rules of admission for licensure that the Supreme Court has promulgated over the probably centuries at this point, decades at least. And there is a Vermont Rule of Admission, 5A1, that states as a prerequisite for admission for applicants to be a citizen of the United States or an alien lawfully present in the United States. That's what the rule presently states. And I did inquire of Andy Strauss, who processes all of the applications, what the numbers are in general. We don't have data points, for example, but the vast majority of people who apply for a Vermont law license or to be admitted to as an attorney are United States citizens. And he estimated that maybe 5 to 10 a year might be someone who's not a United States citizen applying for admission, and there's various steps, including, taking the bar examination, the character and fitness committee. It's a process. But those who are not United States citizens who apply, an example might be a student at the Vermont Law School who has a student visa, and they're applying to take the bar exam. So they would be considered lawfully present in the United States, and there's a whole variety of examples. I didn't know whether or not Jill Diaz, who I know had provided testimony, would be here or not. And I know Jill from when she was Poppy Law Fellow, to ask to try to get a feel for what category they were looking for. If it's somebody, for example, seeking asylum, again, they would be lawfully present. They're going through that process.
Jill testified last week.
Right, I was thinking she might be here today and I could ask for that, but in essence, the Board of Bar Examiners, if there is somebody who is not a United States citizen, but is lawfully present or saying that they are lawfully present, normally they look to whether or not the person's authorized to work. And if they're authorized to work, that would be considered lawfully present. And from what I understand, there's a variety of categories that would fit that criterion. So that's kind of in a nutshell, how the immigration status, I guess, factor right now is taken into consideration in the licensure application process, if that's helpful. We also have what's called a application for an equivalency determination of a foreign law degree. You might have somebody who's studied at a law school abroad and wishes to apply to take the bar exam to practice in Vermont. There's a separate process for that, and that does include the same criterion. If you're not a United States citizen, documentation establishing that you are lawfully present, and they would provide whatever it is, whatever category they were applying under. The student visa is probably the most common, and they would be considered lawfully present. Therefore eligible to take the bar exam, and then from there you go to passing the bar exam. And then there's the character and fitness requirement as well, before you're admitted, offered a license. Then you have the ongoing every 2 years continuing legal education requirements and other.
Right. And the bill wouldn't change any of that. Like I said at the beginning, we aren't trying to change any of the requirements for licensure except for the identification numbers that are. If Jill did testify on the bill, both in writing and verbally, and her testimony was excellent. And I don't want to speak for her, but you should listen to it if you want more information about what she was saying, because she was talking about how it would apply, the bill as drafted would apply to a number of immigration statuses, and including people who would be considered quote unquote undocumented. And it would allow them to get a number to be able to work in a licensed profession, assuming they met the other requirements for licensure. And she gave an example of a paralegal that she just hired who was not eligible to get a law license because of their immigration status, so she had to hire them as a paralegal.
Oh,
So, I don't know all the ins and outs of the requirements for a law license, but I think she was thinking it's much a broader set of people than just maybe a foreign law student or, an attorney that was trained elsewhere and coming in.
okay. I
So,
didn't click the testimony, but it was written testimony, so I read that.
Or you could do
Oh.
YouTube, on the YouTube for the
Okay.
day.
Yeah, because I
Yeah.
don't remember that specific.
So I
verbiage,
think
but
that
I'll listen to it.
maybe it was because we asked her that question, so
Yeah.
she went into
Yeah.
more detail than in her written
So
testimony.
maybe
Yeah.
Olivia would be kind enough to send you the link to the YouTube that Jill testified on.
Okay.
Yeah.
Because I think we're really trying to get at, how can we look at, refugees in particular, or, people who are here who have been trained elsewhere, who with some thoughtful effort, we could bring into compliance with whatever else we need and have them function as lawyers without having them to be paralegals.
Yeah, and also she said that oftentimes when people get authorization to work in a profession and get some kind of alternative ID number, that helps them along the path to get their citizenship or their, other documentation that might be helpful.
And I guess in terms of the person, it would be, and I will just find it, if it's okay, contact Jill directly.
Yeah,
Because, for example, if a person has a foreign law degree, they may not be eligible under the requirements for the education training to.
Right.
Because unless it was a common law jurisdiction, for example, and I know Patty could probably speak with much more clarity than me,
Yeah.
but there, just a foreign law degree wouldn't necessarily mean that somebody would be competent or understanding of the system of law here.
right.
Because primarily it comes down to protecting the public, to ensure that the person's who's representing them and who's trusted with all kinds of critical matters, that they're competent.
Right,
Then
and
you're
that's
probably-
true for all professions. I mean, the competency is different for lawyers than plumbers, but we don't wanna change that. We certainly don't want people to get licenses that aren't competent to do the profession. And I don't know the details of the person that Jill was referencing, but I think that they would be able to tell you.
But we do want people, if they do have a degree from a foreign law school and they were making their future life in America, how can we how can we boot them up so that they're ready to take the bar and ready to practice law here? So that we don't lose all that expertise and could mean that they are great in all sorts of law aspects internationally that we need their expertise.
Right.
Patty, do you wanna weigh in here? I wanna make sure you have a chance to say your piece too.
Yes, thank you for the opportunity to talk on it, and that's a great point. If they are already trained as a lawyer and they have education as a lawyer, they're very likely to be considered under that foreign law degree and that would allow them to come in and take the bar exam. Under that circumstance, I think what we're probably talking about is more the individual who is I'll say undocumented status, right? That they're here and they are undocumented. And so that means that they're missing, we have the requirement that you be a citizen or an alien here, alien here permitted to be here. I'm trying to remember the exact.
Lawfully present.
Lawfully present, yes. And I think there's a gap there, right? We definitely have individuals who've been going through education here in the States who might not be able to check yes on that piece of the box. And I sense that that's where you're really, that the bill is trying to get to. This is a longstanding rule of the Board of Bar Examiners, or the rules of admission. Those are promulgated by the Vermont Supreme Court, but this is really a policy decision in terms of it's certainly a very good policy decision, and we already try to get we have issues with having attorneys coming into Vermont. We also struggle to fill some of those roles. And so I don't think that we're interested in making sure that we have as many opportunities to find qualified folks. So the rules are already very well set in terms of those other qualifications. This perhaps though is an obstacle that the rule requires either citizenship or that they be here lawfully present.
Yeah, I mean, and one of the categories that we discussed with Jill was DACA, and whether or not they would be included. And I don't know specifically, do you know, Patty, if DACA individuals would be, because their legal status is a little gray?
Right.
And I really don't know what your response would be to that portion of the application. Some of them, maybe they are able to say yes, and some of them maybe not. I really don't know. I don't have that level of knowledge about the immigration status.
Okay. Senator Yost, do you have a question?
That was my
Oh, okay,
question, was
sorry.
specifically around, you know, the young people who may have gone to law school here, but because of how they got here when they were 6 months old or 2 years old, may not actually be able to check yes.
So it sounds to me, I'm always a little cautious when it comes to requiring the judicial branch to do anything because of separation of
Yes.
powers. But it sounds to me you already have a rule, and if we were to include you in this bill, that would be trumping your rule. So is your bottom line, you'd rather that we don't include lawyers because you don't want us to do that, or is your bottom line, yes, please include us because then we can update our rules?
Yeah.
Which is it?
Well, to be honest, there's a provision in the Vermont Constitution that allows the General Assembly to revise a rule made by the Supreme Court. I mean, ultimately, so I.
Just like reset their
As
budget.
Patty said, it's basically a policy decision
Okay,
that,
it's our policy decision, you're saying, okay, I was unclear if you were saying it was the Supreme Court's policy
Oh.
decision or ours.
I feel it's always the legislature's policy.
Oh, cool. I'm always just a little cautious. I've, been cautioned by our legislative council multiple times about bills we've been trying to do in this. Hence, trying to change the Constitution, for example. Okay, cool. So you would be okay if we included you in this provision that included lawyers, is what we're
Well,
saying.
yeah, I think it would then require the General Assembly to revise basically the rule that we have in effect now.
Okay.
But you have that ability under the.
5A1 or.
So we
under
wouldn't.
chapter
Okay, I can talk to our
67.
attorney about how we would do that in this. Okay.
So-
I would say.
Go ahead, Patty.
Well, I was gonna say, the only concern that we might have is whether, because if that change happens when we need to look at our rules to make sure that there's no unintended consequence, having folks come to Vermont to take the bar exam, but who don't intend to be here. So we end up with the administrative work of having them take the bar exam, but then they don't intend to practice law here. They intend to actually be elsewhere, and they're going to take advantage of our allowance of them taking the bar and then move it elsewhere. That would be of some concern for us because of the amount of work it is to handle, the bar exam. This is a volunteer board. I can give you more information about that if you'd like, but I'm not sure you need it. So I would say that we would want to make sure we had enough time to look at our rules and to make sure that we were consistent so that we didn't have an unintended consequence of a flooding of applicants to take the bar exam in Vermont, which is basically a bar exam that you can take in 38, I think, states now, because we've gone to a uniform bar exam. So the uniform bar exam can be transferred to other states, and that's the beauty of it, but it creates a problem for us at times if we have folks who come here to take the bar exam but don't actually intend to.
Right, they're just using it as a vehicle to move somewhere else.
Right,
So if you could suggest the two of you, and even you can feel free to contact Jill and get their opinion as well. if you could suggest language that we could include that would meet your needs, not create a floodgate, help, revise Rule 5A1. However it needs, I would love to just get your suggested language that we could include in the bill.
Yeah.
Great,
It's-
and it's called courtesy seating, I guess, and Vermont does not allow courtesy seating for the reasons Patty discussed. We're, like many things in Vermont, we're all volunteers that are
Small and-
administrative. In some states, they have, paid personnel.
Yeah, we're familiar with that.
Yeah, but there isn't really a mechanism to actually enforce it. It's something we request, and we ask if you're applying for admission to Vermont, we assume and hope that you plan to practice in Vermont and stay in Vermont. But as Patty said, there's no right currently the ability to kind of enforce that. But we're happy to explore and talk with Jill,
Okay.
to get a better sense for kind of the scenarios that she's experiencing and prompted.
Okay, that would be great if you could suggest some language so that we can move forward with this bill and include as many professions as possible, so everyone's on the same page. Senator Clarkson, last one.
I have two thoughts here as you go forward with this work. One is some lawyers, particularly refugees or law students who are from a different country in the first place, may want a law degree so they can practice law here, but also live and practice international trade with Vermont and be a law partner here, but maybe live abroad and be admitted there as well. It strikes me that there are lots of reasons that of somebody might want to have a bar, pass the bar here. The second is, I would hope you could create a mechanism and a training process that would enable people who have been trained in the law elsewhere to bring them up to the point where they could take the bar. I mean, so that there's an intentional process where you vet somebody, see that they have been trained elsewhere, bring them on board and onboard them into a process of taking the bar, because they're not gonna be ready to take the bar without some additional training on this. So it would be great to have that opportunity identified.
You don't need to do that for this bill. I mean, that's.
No, but
not
I think
difficult
that's
to
something they
do.
should be thinking about.
But really just, we wanna, the language to include.
Yeah.
Lawyers in this bill.
Right.
And trust that you'll, as lawyers, will get us that
But maybe
language.
that's one of the laws that should be doing.
Whether
But-
they do now, I'm not sure, but I know,
Maybe Jill.
reach out to Jill.
Okay, that would be great, and we would love to vote this bill out as, soon as we can, so we can move on to other bills, so. If you're able to get us something in the next few days, that would be helpful.
Be happy to, and Jill, as you probably know, was heading up the clinic at law school.
Yes,
she
was.
For her present position.
Until she
So
started her
she
new
would have
job.
good insights into, I guess, how many people, what are the circumstances.
Yeah.
of that.
Yeah, that would be great. Well, thank you both, really
Thank
appreciate
you,
it.
very interesting.
That's wonderful.
Yeah.
Good to talk with you.
Thank you.
Thank you, Patty.
Yeah, all right, now we're gonna move.
Feel better,
from
Patty.
lawyers to doctors.
Feel better.
Last but not least, David Hurley. David, are you, I see your name up there, hi. And David, I hope you heard the sort of preface that I started with, because I was in part for you, because there's another bill that you testified on in my other committee that would have changed some of the requirements for the profession. If this is not that, this is just about the sort of documentation numbers and
Oh, she did.
whether or not, like, we could include doctors in this. No, please don't leave, we won't have quorum.
We needed to ask her about this.
So if you could tell us what you'd like us to know, that'd be great.
Well, it's funny when I haven't had much of a chance to look at this because I just found out about this request yesterday, and I've been fully booked and just kind of doing it on the fly here while listening. We've never had a question about anybody not having a social security number, because essentially every applicant has to have worked in the United States to apply, because like the vast majority of states, we require residency training in a ACGME residency program, and they've worked here for 3 years. So they all have social security numbers, and there's never been a question about it. We're, as far as I know, when we went over our application, we did a top to bottom review of our application process last fall, and one of the questions that came up was, why do we ask for social security number? What's the basis for this? And reconfirmed our understanding that we're required to get it for before issuing the license. We have to get it because the Department of Taxes and the Office of Child Support both rely on them in association with some laws that relate to professional licensees. So we have to get them for that. And it sounds like you folks have spent a lot more time looking at this than I have, but I don't know how that would be replicated. I mean, we have tons of people get licenses who are not citizens, but you don't need to be a citizen to get a social security number.
But so this, to your first point, this is a federal tax ID number or a what was the other
Employee
number?
identification.
Employee identification number. Those both work for your first point of the taxes and the child support. So these would be for people who are not citizens. Only citizens can have social security numbers. So you must be already, if you're doing.
Well, I guess, yeah, I guess it's just in the, I mean, maybe the numbers we get are taxpayer identification numbers.
Yeah, they must be something else because.
I mean, actually, I just went online and saw several places where it said you don't need to be a citizen to get a social security number. Everybody can pay taxes. You're not entitled to get social security benefits, but you get a number. That's what I just saw online.
Well, if you could get us some more information about what you require, and if you want to have your legal counsel look at this bill, I mean, we would like to include as many professions so that there's consistency across licensed professions.
Yeah, the other concern I have, and I was just trying to look, there's an organization called the National Practitioner Data Bank, and every state board for all the health professions is required to make reports about licensees who have disciplinary actions or other adverse information. Yeah. And I was just looking and like their guidebook, I didn't drill down into the law yet, but their guidebook talks about you need to use the social security number in there. So I don't know. It sounds like OPR had been involved with this bill, so they may have already looked at that. Again, this is brand new to me. And the one problem I have in helping you this week, we have my employee who makes those reports. You have to get an account with this NPDB to make the reports, to actually go into the system. And she's out this week. She just had a death in the family and she's going to be gone all week, but I could help you next week.
Well, so those, the other states that require, that's for being part of the compact. So are all medical doctors part of an interstate compact, or can you get it just as?
No, I'm not. I wasn't talking about the compact. I was talking about the NPDB, the National Practitioner Data Bank. It's a federal law that requires all medical licensing agencies, all insurance companies that pay malpractice, all employers, hospitals and FQHCs, everybody has to put in adverse information into this NPDB, and we're required to put in identifying information. And the guidebook talks about, putting in the identifying information, including social security number. I didn't have a chance to see if there are other alternatives that are acceptable for that. But the bottom line is everybody, it's, I don't know. There's, lots of people who work in health who are not citizens. I'm not sure that's not something that I have any expertise in.
Okay.
is Social
We
Security
can ask
laws.
we can ask our legal counsel about the NPDB. I think that Jen Harvey would know, but
I'll ask our legal counsel too at the health department. We
that
have
would be great.
Cecily G who works with us.
If you could ask your legal counsel and get us the information, that would be really helpful. If there's a legitimate reason or roadblock that we can't include positions in this, we certainly wouldn't, but if it's possible, just like you just heard with lawyers and teachers, we'd love to be able to do that.
Okay, I'll see what I can do to try and get some answers.
That would be great. Thank you so much, David.
Sure.
Okay, committee, we did a lot of bills, so we're gonna end today.